Suppose two of the biggest police organizations in America can pressure Congress to keep treating law-abiding gun owners as default suspects. Do we really still have a Second Amendment in practice? Or only on paper? I'm talking about the Fraternal Order of Police FOP and the International Association of Chiefs of Police IACP, who just urged the House to reject H.R. 38, the Constitutional Concealed Carry Reciprocity Act of 2025. This fight is happening right now in Congress, and it directly affects every American who carries a firearm, travels across state lines, or ever gets pulled over while armed. At stake are your Fourth Amendment protections against unreasonable searches, your Second Amendment right to carry for self-defense, and your ability to hold officers accountable under 42 U.S.C. Section 1983 when they ignore those limits. In this video, I'm going to walk you through exactly what H.R. 38 does, what these unions admit in their own letter, and what it all means for your freedom. All right, let's get into the meat of this and start with what H.R. 38 actually does, because there's a lot of noise around this bill and very little clarity. In the simplest terms, this proposal says if you are legally allowed to carry a concealed handgun in your home state, you can carry that same handgun concealed in other states that let their own residents carry. Think of it like your driver's license. When you cross a state line, you don't suddenly forget how to drive or become a criminal for getting on the highway. H.R. 38 takes that same common sense idea and applies it to concealed carry. Now, that does not mean every single person gets a free pass. If you are a felon, a prohibited person, or you could not carry legally at home, H.R. 38 does nothing for you. This bill rides on your home state's rules. If your state says you're good to go, and the state you're visiting allows its own citizens to carry, then you get to carry too. What the bill really does is stop states from using their own patchwork of rules to turn travelers, truckers, and ordinary families into accidental felons just because they crossed an invisible line on a map. There's another piece baked into H.R. 38 that a lot of people miss, and this is where the unions really start to sweat. The bill doesn't just say, you can carry. It also says, if a government official detains you, arrests you, or harasses you in violation of these protections, you can take them to court. It ties your right to carry to a civil rights remedy. In other words, the right is not just symbolic. There are consequences when it is violated. For officers and agencies that are used to treating armed citizens as fair game for fishing expeditions, that is a major culture shock. That brings us straight to the joint letter from the Fraternal Order of Police FOP and the International Association of Chiefs of Police IACP. These are not small players. Together, they speak for a huge swath of rank-and-file officers and command staff. In their call to action, they urge the House of Representatives to reject H.R. 38, and they frame it as a threat to officer safety, to their ability to do the job, and to something they care very deeply about: their protection from lawsuits. The letter starts with a hard truth we should all acknowledge. Disturbance calls and traffic stops are dangerous. The unions point to numbers from 2024: dozens of officers shot while answering disturbance calls, dozens more shot during traffic stops. Anyone who has worn a badge knows those numbers are not just statistics. They represent real people, real families. But here's the pivot. Instead of saying, we need better training and better tactics, they say, in effect, we need to keep the power to treat anyone with a gun as a potential criminal so we can control the scene. That is where they collide head-on with the Constitution. One of their core complaints is that H.R. 38 would prevent officers from detaining or arresting someone solely for violations of state or local gun laws tied to possession, transportation, or carriage. They specifically mention school zones and federal lands and warn that officers will be hamstrung. When you strip away the legal phrasing, what they are saying is this: if they see or suspect a gun, they want the default option to be a stop, a disarm, and a prolonged investigation, even when there is no other sign that a crime is being committed. They also argue that the bill would allow citizens to sue officers and agencies when those lines are crossed, and that officers would not be shielded by qualified immunity in those cases. From the union's perspective, that means every contact with an armed citizen carries a new level of personal risk. From my perspective, as someone who cares about individual liberty, what they are really objecting to is the idea that their decisions will finally be judged against the actual standard of the Constitution, not just department policy or habit. To see how flimsy some of these complaints are, you have to step back And remember what the Supreme Court has already said about the right to keep and bear arms. In District of Columbia v. Heller, the court made it clear that the Second Amendment protects an individual right to possess a handgun for lawful purposes, especially self-defense in the home. 2 years later, in McDonald v. Chicago, the court confirmed that this right is so fundamental it binds not just the federal government, but the states and cities as well. Those cases put the Second Amendment on the same footing as other core rights like free speech and freedom of religion. Then came New York State Rifle and Pistol Association v. Bruin, which pushed the point into public carry. New York had a system where you had to prove a special need to get a license to carry outside the home. Ordinary self-defense was not enough. The Supreme Court struck that down and said that when the text of the Second Amendment covers your conduct like carrying a handgun in public for self-defense, the burden flips. It is not on you to prove you deserve the right. It is on the government to prove that any restriction fits within this nation's history and tradition. That is a huge shift away from treating carry as a special privilege that bureaucrats can ration. Now, pair that with the Fourth Amendment, which protects you from unreasonable searches and seizures. Under long-standing law, officers can only stop and frisk you if they have reasonable, articulable suspicion that criminal activity is afoot. That is not supposed to be a hunch. It has to be based on specific, explainable facts. In a world where carrying a gun is broadly legal, simply seeing a firearm by itself is not evidence of a crime. It might be completely lawful conduct. A great example of this tension is the Pennsylvania Supreme Court case called Commonwealth v. Hicks. In that case, a man with a valid concealed carry license was stopped, disarmed, and handcuffed outside a convenience store simply because someone reported that he had a gun. There was no allegation he was threatening anyone or committing any other offense. The state tried to argue that the mere presence of a firearm justified the stop. The court disagreed and said that even in the name of safety, that kind of intrusion exceeded constitutional bounds. Legal analysts looking at Hicks have boiled it down to a simple rule that ordinary people can understand. In places where carrying a gun is legal, officers cannot treat he has a gun as the sole reason to stop, detain, or disarm someone. The fact that you are armed can be one factor in a larger picture, but it cannot carry the entire load by itself. That is exactly the logic that the unions are fighting against when they demand the continued power to treat every armed citizen as an automatic suspect. The 14th Amendment ties all of this together by requiring states to apply fundamental rights equally and by incorporating the Second Amendment against the states. After McDonald, there is no serious debate that the right to keep and bear arms binds state and local governments. Equal protection then adds another layer: you cannot be treated as a second-class citizen just because you are from out of state. If a Virginia resident can carry under Virginia law, and you are carrying under a lawfully equivalent status from Vermont, the government does not get to pretend your right is weaker because your driver's license has a different state on it. So when the unions say H.R. 38 would prevent officers from detaining people to check whether they are properly licensed back home. What they are really admitting is that they want to keep using travel and residency as excuses to downgrade your rights. The bill says no. It says if you are lawful at home and you are in a state that allows carry, you stand on equal footing with the locals. That is exactly how the 14th Amendment is supposed to work when it comes to fundamental rights. Now, let's talk about the enforcement mechanism that really makes this bill more than just a nice idea on paper. We have a federal civil rights law, often called Section 1983, that lets you sue state or local officials who, under color of law, deprive you of rights guaranteed by the Constitution. That law has been used for decades in cases involving excessive force, unlawful searches, and false arrests. H.R. 38 essentially plugs into that same framework and says, if they violate your right to carry under this law, you can take them to court under that civil rights theory. Standing in between citizens, and that remedy is something called qualified immunity. That doctrine, created by the courts, says that government officials are protected from personal liability unless they violate a right that was clearly established at the time. The idea, at least in theory, is to protect reasonable mistakes, not blatant abuses. In practice, it has often been applied so strictly that unless there is a prior case with almost identical facts, officials walk away. The reason the unions fixate on qualified immunity in their letter is because H.R. 38 makes it much harder to hide behind that shield. by spelling out that you cannot detain, arrest, or disarm someone solely for carrying a firearm in compliance with the law. Congress would be drawing a bright line. Ignore that line, and you are no longer in the realm of a reasonable mistake. You are in the realm of knowingly trampling a clearly defined right. That is exactly the kind of situation where qualified immunity should not apply. So, what does all of this mean for you, the person who actually carries a gun or is thinking about it? It means that under a regime like H.R. 38, your experience on the side of the road should start to match what the Constitution already says on paper. If you are stopped for speeding, the stop is about speeding. If there are independent signs that you are drunk, high, or committing some other crime, officers can and should investigate that. But the mere fact that you are armed and that you admit you are carrying lawfully should not be treated as a blank check to drag you out of the car and tear your life apart. It also means you have a clearer path to push back when those lines are crossed. Instead of being told, "Sorry, that's just how we do it here," you would have a federal standard to point to and a civil rights remedy to pursue. That does not mean every officer becomes a villain or that every encounter ends in a lawsuit. What it means is that the balance of power shifts a bit back toward where the founders intended it to be: government as the servant of the people, and the right to keep and bear arms treated with the same seriousness as the rest of the Bill of Rights. At its core, the fight over H.R. 38 is about whether constitutional rights end at state lines and whether officers should be accountable when they ignore them. The FOP and IACP argue that protecting citizens' rights undermines officer safety. I contend the opposite. Rights are not negotiable, and accountability is not optional. The Supreme Court has said that the Second Amendment guarantees an individual right to carry and that the 14th Amendment extends that right to the states. If unions oppose a bill because it enforces these truths, that tells you where the real problem lies. Stay informed, stay vigilant, and never surrender your liberties.